Hi everybody, it's Evan Brown, intellectual property and technology attorney in Chicago. If you are a software or technology vendor, here are 3 things you can do right now to prevent or lessen the impact of problems you may have in performing under your contracts for services such as development, implementation, and support. The first thing to do is look at your contracts and see which ones contain actual expressed material assumptions that have failed or will fail, perhaps because of some governmental action or unavailability of personnel. These might be in the body of the services agreement or perhaps in the statement of work. For example, the parties to a contract could say that they assume there won't be a major economic downturn during the term of the contract, or they assume that there will be a workforce that is actually capable of performing the services. On this point, we can learn an important lesson from IBM, and that is to do what is required when there are failures of material assumptions. In 2006, the state of Indiana signed a $1.3 billion contract with IBM to revamp the technology of the state's welfare system. The economy went south after that in 2008, and in the complicated breach of contract litigation that followed, IBM argued, among other things, that the economic downturn resulted in the failure of one of the material assumptions of the agreement. IBM argued that the court should consider that failure of assumption when deciding whether IBM had materially breached its contract to develop and deploy the system. The Indiana Supreme Court rejected IBM's arguments. Why? Well, not because the economic downturn was not a failure of a material assumption. It might have been. Indeed, the contract specifically said that the parties had made this material assumption that the economy would not take a downturn. But IBM did not do what the contract required in light of the downturn. It did not submit a change order request in response to the failure of the assumption as the contract required. The second thing that you should do right now is look to see whether it would be appropriate to start the change order process with your customer anyway, even if it's not because of some failure of a material assumption. This gives you a good opportunity to actually communicate with your customer to assure them that in the long term, you're going to be there for them as a vendor. And it also gives you the opportunity at the same time to develop goodwill and trust with your customer. And that's going to benefit us all when the economy improves. The technology space in particular is going to see a lot of growth. And these customer-vendor relationships will be valuable. The third thing you should do right now is look at the force majeure provisions in your contracts. Do they require you to do something before claiming force majeure? Going back to the IBM Indiana litigation, IBM also claimed that severe flooding in the state in 2008 was a force majeure event that excused IBM's performance. And so again, as with the argument for failure of material assumption, IBM did not do what it was required to do under the terms of the contract to avail itself of this excuse in performance. So there you have it. You should look at any material assumptions, consider change orders, and see whether you have to do anything to claim force majeure. Thanks for watching. Please like this video and subscribe to this channel. Also, please go over and read my blog at internetcases.com. If I can help you with anything, please drop a line or give me a call. Thank you.